560 United States of America versus David Taylor.
Good afternoon, Your Honor. Sarah Cohen appearing on behalf of the United States.
Good afternoon.
Good afternoon, Your Honor. Scott Rosenblum appearing for Pastor David Taylor.
Okay, good afternoon. Mr. Taylor, can you please approach and state your name for the record?
David Taylor.
Okay, thank you. Today is the date set and time for an arraignment and a detention hearing. Let's do the arraignment first. Mr. Taylor, did you get a copy of the indictment?
Yes.
Okay, you need to speak in the microphone.
Yes,
Okay.
Your Honor.
Okay. I do have in front of me an acknowledgement, and it's signed by you and your lawyer. Is that right?
Yes, Your Honor.
Okay. And this document states what you have been charged with and the maximum penalties you could face if you are convicted or plead guilty. You've been charged in this indictment with count 1, conspiracy to commit forced labor in violation of 18 U.S.C. section 1594. That carries a potential maximum penalty of 20 years imprisonment and a fine of up to $250,000. Counts 2 through 9 charge you with a violation of 18 U.S.C. section 1589, which is forced labor. Each of those counts carries a potential maximum penalty of 20 years imprisonment and a fine of up to $250,000 on each count. You've also been charged in count 10 of this indictment with conspiracy to commit money laundering in violation of 18 U.S.C. section 1956. That also carries a potential maximum penalty of 20 years imprisonment, a fine of up to $500,000, or twice the value of the properties involved in the money laundering transactions. You also need to understand that the court could impose consecutive sentences if you are convicted of more than one count. Mr. Taylor, do you understand what you've been charged with in this indictment and the maximum penalties you could face?
Yes, Your Honor.
Okay. Counsel, are you ready to enter a plea?
Yes, Your Honor. We'll waive the formal reading of the indictment and enter a plea of not guilty to each count.
Okay. I will enter a plea of not guilty on each count, and the record will reflect that Mr. Taylor has now been arraigned on the indictment. So the next matter is the detention hearing. And before the government starts its proffer, I just want to put on the record that in advance of this, I've reviewed not only the indictment, but I've also reviewed the memorandum that the government filed in support of detention. I've also reviewed defendant's memorandum in opposition to detention that have been filed, as well as obviously the reports of pretrial services, both from this district and the one that was prepared in the district where he made his initial appearance. So just so you know what I have reviewed, and I am also familiar with the proceedings with the co-defendant. So go ahead.
Thank you, Your Honor. With that recognition by the court, the government's argument today and factual proffer will be limited. As the court is well aware, Taylor is charged with forced labor, and Congress requires a presumption of detention. This presumption reflects Congress's substantive judgment that particular classes of offenders should ordinarily be detained prior to trial, such as David Taylor. It is the government's argument that the defendant will not meet its burden of production. However, if the court finds otherwise, the government's argument today will focus on 3142 factors, beginning with the nature and circumstances of the charged offenses. According to the evidence presented to the grand jury and reviewed by this court, David Taylor was a self-proclaimed general of a very unusual and brutal regime. And he was, according to the evidence, a serial sadist. And that is no exaggeration. For 11 years, in 4 states, over a decade, he terrorized and traumatized workers with violence, threats of violence, sleep deprivation, medical deprivation, and food deprivation. Contrary to the defense brief, victims and witnesses will testify that David Taylor, defendant number 2, Michelle Brannon, and others in the organization, including some who are sitting in the courtroom today, assaulted others in the organization, including, to date, at least one minor who has come forward. Specifically, witnesses thus far who have been willing to come forward have reported that approximately 10 members who have assaulted other people within the organization. Because of the nature of the public proceeding, the government is not going to identify those people at this time, but there are approximately 10, again, including some seated in this courtroom today. Victims and witnesses will also testify that they were deprived of food, sleep, and medical care. Their testimony is corroborated overwhelmingly by Taylor's orders and threats to his victims that have been documented. For the record, the government is going to place some of those threats directly from Taylor into the record, notably with the times. Beginning on just one at 12:26 a.m., Taylor texted an armor bearer. As the court knows, an armor bearer is Taylor's personal slave. He instructed the armor bearer as follows: "You'll have to raise $164,000 today." To clarify, the armor bearer was responsible for passing on that order to the workers. "Each hour you will fall behind, consequences will start. We will mess with the food. You will fast from the regular food or abstain for a while. Those who do not push in their calls individually and as a team with the right amount of people and closing numbers at 6 p.m., they don't eat dinner at all. They might get a snack before bed, but not much, and this regiment will go on every day for 21 days until they obey. Take away the food. Exclamation point, exclamation point. There will be other consequences. We must make them fast and pray." Another one at 3:55 a.m., Taylor texted the same armor bearer: "Those in the top 9 that don't do well will stay up and close and stay on top of the delinquents. Put the pressure on them for not having their time off. Nor food. They will fast." At 3:52 a.m. on another date, Taylor texted his armor bearer: "Let everyone know we have to raise at least $50,000 by 12 midnight if this happens. The top 9 and those who did well can rest, but the others who didn't will stay up until 4 a.m. and study notes, and they will wake up at 8 to 9. And if they don't do good the first 5 hours, they will not get lunch." On another date, 7:57 a.m., there is evidence of consequences when people are sleeping and are having a hard time waking up. He texts his armor bearer: "Pour water on everyone's faces that's halfway sleeping and not working. Wake them up now. My next level of judgment tomorrow is that it won't be just 4 a.m. It will be every hour you waste in the day will be added on past 4 a.m. In all capital letters, tell them all to stand now and you throw water on their faces." Later in the text, "You tell them I don't care about them being sick." On another date at 3:23 a.m., Taylor texted to his armor bearer: "I can't be kind to you letting you start later and sleep in. I can't be kind with none of you. You're all working until 4 a.m. Now, I don't care if you're tired. You've crossed the line. You're going to work all night and get up in the morning." In another text, Taylor texted a group of workers: "You're not going to bed tonight until you raise $33,000. And as the court knows, the $33,000 and all the other money that Taylor is insisting being raised is not for the benefit of the community. It is for the benefit of David Taylor and Michelle Brannon. On another date at 1:44 a.m., Taylor texted a group of workers in capital letters, point blank: "If you don't work, you can't eat." On another date, Taylor texted a group of workers, warning to the whole staff in capital letters: "If you don't work and learn closing like we told you, then you won't eat." There are more. They are in the brief, and there are more in evidence. In addition to the threats that are corroborated by victims and witnesses, FBI agents are now investigating even more disturbing evidence, in addition to the forced labor. There is evidence now that Taylor coerced some female workers into providing masturbation videos and sexually explicit photographs to Taylor. The female members who have disclosed And there are more in evidence. In addition to the threats that are corroborated by victims and witnesses, FBI agents are now investigating even more disturbing evidence in addition to the forced labor. There is evidence now that Taylor coerced some female workers into providing masturbation videos and sexually explicit photographs to Taylor. The female members who have disclosed this to the government to date explain that Taylor demanded this material, that they were fearful of disobeying him, and they felt they had no choice but to send Taylor what he demanded from them. In addition, minors have come forward to the FBI. They have been recently interviewed. They have corroborated the forced labor scheme, including physical assaults. They have reported their own psychological and physical abuse and their own trauma during their involvement in Taylor's organization.
By Mr. Taylor?
Yes.
Okay.
Or instructed by Mr. Taylor. The serious nature and circumstances of the charged forced labor, as well as the newly developing evidence, as well as the money laundering detailed in the government's brief, unquestionably weigh in favor of detention. Moving on to the weight of the evidence, the danger Taylor poses is particularly insidious. Congress, of course, recognized this danger in designating forced labor as a presumption of detention case. But there's more than just forced labor. Taylor faces a strong incentive to flee, particularly because of the sentencing guidelines and the statutory maximum penalty. Putting aside the 20-year maximum penalty for a moment, the government's initial estimated calculation for the forced labor charges is 151 to 188 months, and his guideline range for money laundering is similar, 151 to 188 months. It's important that we all understand that forced labor is not just about physical assaults and physical abuse. It is about the psychological trauma and coercion that occurs. And this was happening on a daily basis for over a decade. So to remove David Taylor from the organization is not enough. The fear persists for his victims, not just because he's physically removed. The psychological fear and the psychological trauma continues. The history and characteristics of the defendant. He has no employment outside KOGGC. He does not have significant family or community ties to this district. And while it is true that he has no prior criminal convictions, he has admitted publicly and in messages that he used to be a gangster in his teenage years, very bad in shootouts, etc. So apparently, prior to this forced labor sinister organization that he decided to start, he was involved with violent behavior. And then it's important that the court recognizes that he doesn't have any criminal convictions because he was engaging in a criminal enterprise that was extraordinarily sealed for the past 12 years. In addition to the lack of legitimate ties to this district, the government's financial investigation, which importantly remains ongoing, establishes that Taylor has numerous sources of funds to flee, as detailed in our brief. In addition, the government has just recently learned that Taylor has another source of funds. So this is a source that is not identified in the government's brief. He has an additional cashback debit card account that currently has $12,195.10 in it, and he has an online savings account that has $130,910.23 in it, and that is as of today's date. If the court has any questions about access to funds or the seizure of funds, Adriana Didel, The chief of our office's Money Laundering and Asset Recovery Unit is here to answer the court's questions.
Okay.
The government also pointed out in its brief that the funds will continue to grow based upon the conduct of people in the courtroom because they are actively soliciting additional funds. And the manner in which they are doing it is quite frightening. For example, in a broadcast recently, members of the organization stated, quote, "We're in a war. We're in a war, and it's time for you to decide if you're a warrior or you're not." Moving on to the nature and seriousness of the danger to any person or the community. In addition to the intimidating forced labor conspiracy that is discussed in great detail in the government's brief, as the government has noted, there's developing evidence that Taylor coerced women to provide him sexually explicit videos and pictures. His sexual predation alone makes him a danger to the community for several reasons. First, it is very apparent to investigators that Taylor has an excessive need for sexual gratification, and it will not be controlled with bond conditions. Because Taylor collected these sexually explicit materials electronically, this material may be in the possession of current members of the organization or former members, or may be stored by Taylor in unknown locations. Women remain fearful that Taylor or someone at his direction will distribute this very private, explicit, and sensitive material. As detailed in the government's brief, also, during Taylor's meetings and online broadcasts, he uses words like war and battle. He claims he's preparing soldiers. He calls himself a general. And he describes how he's training the end army. His members are entitled to protest, Your Honor, but as I speak here now, they're outside the courthouse. And that should be noted. They are carrying on their war message, even as I speak. It is important to note as well that one member of the organization who has been attending court proceedings did interfere with the government providing assistance to victims of this organization. Specifically, on August 27th, victim witness services were present in Tampa when the search warrant was executed. There were nonprofit organizations present as well. These were victim services personnel who were offering help to victims: food, medical care, a phone, whatever they needed. And there were victims who wanted the help. And a person within this organization, a high-level person, a person who admitted that he was number 3 in the organization, who is sitting in the courtroom today, came to that location and convinced those people to leave and not get help. That's the kind of organization that we're dealing with. In addition, Taylor himself and others at his direction have threatened, harassed, and stalked members, either at their indication that they wanted to leave the organization or after they left. Just recently, the government has received descriptions of people, from people, who want us to know the kind of harassing activity that occurs. So there are people out there that are very concerned about David Taylor being released into the community and the kind of harassing and stalking that will occur by him or anyone at his direction. So given Taylor's reign of terror over his victims, his leadership role, his loyal following, and now his sexual exploitation of women, and his evangelizing of violence and obstruction and defiance of law enforcement, Taylor would clearly be a danger to the community if released. Moving on to the recommendation by Pretrial Services. Pretrial Services recommended bond. So at this time, I'm going to explain why the bond conditions are absolutely and wholly inappropriate. With regard to the bond address, the Ocala House is a formal location of the forced labor. The North Carolina address is where David Taylor was arrested. Contrary to his statements to Pretrial Services in North Carolina, he has been living at that location for approximately 5 years. There's an individual referenced in the Pretrial Services report. I can state his name on the record if the court wishes, but for now,
Well, if it's stated in the Pretrial Services report, I think it's fine. Go ahead.
Thank you. Paul Adom, A-D-O-M.
Right.
Taylor has referred to him as floor manager and stated that he is responsible for driving everyone and keeping order. He runs an organization called Kingdom Restoration for All Nations, which is in Durham, North Carolina. It is directly next to the house where Taylor was arrested. Adom's organization and Taylor's organization have been financially entwined. And I can get into the details if the court wishes, but suffice it to say that there is money going back and forth. And that money has been going back and forth for many years. Adom was in Houston, Texas when the search warrants were executed on August 27th. He was there with his wife. And they had a room. So they are both members of the organization. Moving on to another individual, Alyssa Billow is also known as Alyssa Kay. She was interviewed on August 27th. She said that the Edgewick house is Paul's house. And she also stated to law enforcement that that house was used to house male members of the organization when they came to North Carolina. It's also important to note that an apartment nearby that address is leased under defendant number 2's name, and it has been used to house female members when they travel to North Carolina. And specifically, 2 members of the organization were staying at that nearby apartment. Regarding the defendant's son, like defendant 2's son, is a member of the organization. In fact, his son is listed as director in KOGGC documents. So he is a member as well. I referenced Alyssa Billow, also known as Alyssa Kay, and her statements regarding the address in North Carolina, but with regard to her having contact with KOGGC, she is a member of the organization as well. Specifically, she's been living with Taylor, and she's been instructing his workers in the manner described by the government today and in her brief. She serves Taylor, much like an armor bearer does, but she's female, so I will leave it at that. She also has control over Taylor's personal accounts and assets. Another individual in the courtroom, and also suggested by Pretrial Services to take care of David Taylor, is his armor bearer. As we describe in our briefing, an armor bearer is Taylor's 24/7 servant. And for the record, 2 other armor bearers are victims in counts 8 and 9 of the indictment. They do whatever Taylor orders them to do. That's their job, and that's what they've been trained to do. And this has included over the years everything, literally everything, including transporting women to have sex with David Taylor and to give the women Plan B contraceptives. Gwen also has knowledge of Taylor's accounts and assets, and he corresponds with other members daily on behalf of Taylor. Notably, as pointed out in the government's brief, but I'll highlight some additional inaccuracies in the Pretrial Services report. And these inaccuracies are the result of David Taylor's lies to pretrial services. He has never been an honest person. We know that from the criminal activity. But when faced with court proceedings and the serious nature of court proceedings, he couldn't be honest with pretrial services. He stated that he was living in St. Louis when he wasn't. He's been in North Carolina for many years. Daniel Gwynn has been Taylor's armor bearer, not merely a caretaker or a friend. Notably, David Taylor told pretrial services that he was with KOGGC for a specific amount of time, but as described in the government's brief, before KOGGC, Taylor ran JMMI, and he has run both of those organizations for much longer than the mere 8 years that he admitted to pretrial services. And notably, the only reason, I shouldn't say the only reason, one of the reasons he changed the name is because JMMI lost its nonprofit status. I'm not sure why David Taylor left out additional international travel. Of course, lacking a passport will prevent international travel, but again, just pointing out his dishonesty that he does not admit to all of his international travel. And of course, his financial disclosure is far from accurate based upon the sources of funds to flee that's highlighted in the government's brief, and notably the additional money that the government was notified of today. David Taylor told pretrial services that he merely had one personal checking account with a very minimal amount of money in it. But as described in the government's brief and today, David Taylor has access to a wide range of different funds. And as in any complicated and purposeful hiding of assets, there will be additional sources that the government has not yet located. And again, Adriana Didal can discuss that with the court if the court wishes. And the last thing to note for the record, as I'm sure this court is aware, is that although defendant number 2 is on bond, her condition imposed by Judge Berg was that she have absolutely no contact with any individuals, former or current, in the organization, and none of the funds can support her manner of living in any way. So that the recommendation of pretrial services in this case doesn't even match defendant number 2's bond conditions. Of course, it is the government's position, as discussed in the brief and today, that absolutely no condition of bond is appropriate in this case, and the defendant should be detained.
Thank you. Counsel.
Thank you. May it please the court, Your Honor. I'm trying to conditions or a combination of conditions that will satisfy this court that he's not a threat to leave, that he'll be here to defend himself, and he's not a danger to himself or to anyone else. Thank you, Your Honor.
Thank you. Does the government have any rebuttal? And I'm particularly interested in, if he were to be released on bond, where would he go, and would you be comfortable with any place that he might be going where he would not pose a danger?
The answer is unequivocally no. There has been no proposed address.
Well, there have been, Your Honor.
Well, I understand what's in the pretrial services report. Okay.
And I provided the pretrial services officer with another address after our meeting today.
Okay.
If I had been allowed to finish my sentence, the sentence was going to be, there's been no proposed address in this district where David Taylor will live alone. And even if that was proposed, he has no money outside of the organization to fund that house. And because of all the reasons in the government's brief and the argument today, the government submits that David Taylor, even living alone, even in the Eastern District of Michigan, is a danger.
Because he is the leader.
Because he is the leader, because of all of the facts of this criminal activity, because of his overwhelming coercive and threatening and terrorizing behavior for over a decade. And I want to emphasize a couple of points and correct the record with regard to just a couple of things, Your Honor. First of all, the court understands this, but for purposes of the record, the organization has sought for decades money from individuals without informing those individuals the nature of this criminal organization. So the emphasis on the organization's reach to hundreds of thousands of people emphasizes the danger of that criminal organization and the danger of it continuing, because donors are not informed of the nature of this organization, the victimization that has occurred, and that the government submits remains occurring. Whether members admit that they're victims or not, they are victims of David Taylor and Michelle Brannon. I want to clarify for the record with regard to the number of people that the evidence currently shows have assaulted other members within the organization. If the government was unclear, I apologize, so I'm clarifying now. There are substantive counts in the indictment with regard to victims, and that number is as the defense counsel stated. The government's argument today is that the evidence thus far has established that approximately 10 members of the organization, including David Taylor and Michelle Brannon, have assaulted other individuals in the organization, including a minor that has come forward recently. With regard to the sexual material that the government is uncovering, the government will make it perfectly clear that the government is not infringing upon an adult's desire and acts in furtherance of that desire that is consensual and between consensual adults. The danger here is that, one, the defendant was coercing the individuals and, in fact, grooming individuals to be either subject themselves to this or to eventually succumb to David Taylor's coercion and needs for this kind of information. And the evidence is also suggesting at this time, and I've told defense counsel it's an ongoing investigation, is suggesting that the women who are providing these videos to David Taylor at his demand are providing it as part of their forced labor, just as they were forced to make calls, just as they were forced to raise money. David Taylor required that they provide sexual material to him. So it was part of their forced labor. And the government is not going to put a number on it today. And I've told defense counsel that's an ongoing investigation. But in light of that ongoing investigation, in light of the material that we have uncovered, and in light of the messages that David Taylor has sent to these women that we are now reading, he is unquestionably a danger to the community and specifically to the women that he coerced into sending this material to him. So for all of those reasons and the reasons cited in the brief, the government submits to this court that David Taylor unquestionably is a danger to the community and a risk of flight.
Thank you. The court will take